In compliance with Chapter 231 of the Open Public Meeting Act of the State of New Jersey, adequate notice have been given to all members of the governing body, the local source, and the Westfield Leader, the two newspapers designated to receive such notice. This notice is also posted on the Borough Hall bulletin board. Let's all stand for an invocation from Councilman Messler, please.
Please, Lord, protect the Mountainside Fire Department, Police Department, and Rescue Squad as they protected the borough of Mountainside. Please have prayers for the people of France and the tragedy that they just experienced. Amen.
Amen. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, Martha, roll call, please.
Councilwoman Andre?
Here.
Councilman Dierkes?
Here.
Councilman Lane is absent. Councilman Messler?
Here.
Councilman Mortimer?
Here.
Councilman Turner?
Here.
Okay, first we have the approval of the regular session meeting on October 20th of 2015.
So moved.
Second.
We have a motion, we have a second. Poll the council.
Councilwoman Andre?
Yes.
Councilman Dierkes?
Yes.
Councilman Messler?
Yes.
Councilman Mortimer?
Yes.
Councilman Turner?
Yes.
Next, we have the work and executive session meeting for November 3rd, 2015.
So moved.
Second.
Poll the council, Martha.
Councilwoman Andre?
Yes.
Councilman Dierkes?
Yes.
Councilman Messler?
Yes.
Councilman Mortimer?
Yes.
Councilman Turner?
Yes.
Tonight, we get to do one of the things that we enjoy doing the most, which is to honor the youth of not only Mountainside tonight, but also some of the youth of Berkeley Heights. The girls work very well together, and it certainly exemplifies the melding between Mountainside and Berkeley Heights at probably one of its greatest heights. Fortunately, I was actually in attendance for some of these victories that we're going to talk about tonight, and these girls did a tremendous job. They weren't always the biggest or the fastest, but certainly, from what I could see, they had the most heart, and they certainly had some very good coaching. And I see the coaches out in the audience tonight. So tonight we're going to do what's called a resolution of commendation, and Mr. Turner will tell you the significance of that.
Mr. Turner? Does anybody know what a resolution is? No? Good, neither do I. A resolution is it's not quite a law, it's a statement that actually becomes part of Mountainside's history forever and ever and ever and ever. So when you young ladies are grown up and you have families of your own or grandchildren of your own, and you're sitting back during Thanksgiving dinner one day, and you start talking about how what age group was this? U12? How your U12 soccer team was so successful, and they don't believe you. You say, go down to the Borough Hall of Mountainside, New Jersey, or call the Borough Hall of Mountainside, New Jersey, and look up a resolution of commendation that I got, and you give them the date and the year, and it doesn't matter whether it's 5 years, 10 years, 20 years, or 100 years. As long as Mountainside is still here, the resolution is always part of Mountainside's history. So that's basically what a resolution is. So tonight, you're becoming a documented part of Mountainside's history. Okay?
Okay,
Best I could do.
so now let me read the resolution. Okay, whereas the Berkeley Heights Youth Soccer Club U12 Girls Galaxy brought home the state championship title of New Jersey Youth Soccer President's Cup with a 2-1 victory over the Barrington Galaxy on Sunday, November 1st in Lawrenceville. Whereas the championship game between Berkeley Heights Galaxy and the Barrington Galaxy came down to penalty kicks after both teams scored 1 goal in overtime. Berkeley Heights would prevail by outscoring Barrington Galaxy 4-1 in penalty kicks. Whereas the Berkeley Heights Galaxy team, which is made up of players from Mountainside and Berkeley Heights, opened up this tournament beating the Pascal Red Devils 1-0, defeating the Lawrence Hammett Leopards and the Ronkonkoma Valley SCRV United Premier team in the final round 2-1. Whereas Berkeley Heights Galaxy will advance to represent New Jersey youth soccer in Region 1, consisting of teams from Maine to West Virginia. Some of the things that did not make it into the resolution, which I think are also worth noting, is that they also won their New Jersey NYSA Flight 1 play, where they clinched after 9 games first place when they beat the second place Union MPD Gunners. And also, according to Got Soccer, the Galaxy are ranked 67th overall in the state of New Jersey. Whereas the team consists of Allie Post, Julia Messner, Sarah Zalis, Lauren Popropke, I got them wrong, I'm sorry, Victoria Cardilois, Abby Pereira, Katie Pilawato, Gianna Chichamara, I got that one, thank God. Danielle Kang, Catherine Messner, Reagan DeMarco, Gillian Ham. They were coached by Jay Post, Kristen Chichamara, Rick Ham, Ed Kang, and Jose Pereira. Now, therefore, be it resolved by the mayor and council of the Borough of Mountainside that the U12 Girls Galaxy is hereby commended for their achievements. Congratulations. We ask each one of the girls to come up and we have a resolution that you can take home with you tonight, okay? Okay, let's start with Allie. Where's Allie Post? Okay, stay up here because I know they're going to want to have pictures of you guys. Okay. Julia Messner.
She's not here.
Julia, and I guess her sister's not here either, right? Is that her sister, Catherine? Yes. Okay. Now, if I get the names wrong, now you can correct me and don't feel bad, okay? We have Sarah Zalis. Zalis, okay, congratulations. Congratulations. Victoria Cardinelis. Okay. Next we have Abby Pereira. Okay, next we have Katie Kawada? Alawoda, okay, I'm sorry. Next we have Gianna Chichamara. Okay, next we have Danielle Kang. Okay, and, oh, we got 2 more, okay. Reagan DeMarco. Then we have Gillian Ham.
Gillian.
I'm going to ask the coaches to come on up also. I think we might be running out of resolutions, but still they can come up. We have Jay Post, Kristen Chichamara, Rick Ham, Ed Kang, and Jose Pereira. So why don't you girls come over here and we can get a picture. You girls stand in the front and the coaches will stand by. First thing you got to do though is face the TV camera so you guys get on TV. Come on, this is your big
Hi, the channel.
this is your big moment. From the front row.
There you go.
Okay, now I know you girls have a song that you usually sing after you win the game. If you want to do that, you guys can do that now. Go ahead.
Look at the picture first.
Look at the camera and sing your song, whatever it is that you guys do. Come on.
Go, Katie. Do it.
All right, congratulations. Okay, now take one serious picture. You know how it goes, girls. Come on, one serious, then you can do what you want for the other one, okay? That's right. It's probably going to make the paper, too. I don't know if the coach, Ed, you want to say something?
Sure.
If you can get the girls out of the front of the camera.
The coaches and I really are proud of these girls. They fought tooth and nail for a lot of these games. They're one score nail biters for each one of these games, and they weren't always necessarily the fastest and strongest, as Mr. Mayor said, but they had the most heart. They showed the most cohesiveness and the best teamwork among the teams that they played. So, the parents, we were all very proud of them when we started the tournament for the state championship. Quite honestly, I just thought maybe win one or two games and we'll just kind of get them some good experience, but they exceeded all of our expectations and then some. So we wanted to, we're very honored to have this ceremony for them, and it's great for them to be have this sort of event as they, hopefully as they grow up, they'll remember this fondly. Thank you.
And the community commends you, girls. Great job, okay? Now, I know all you girls are just dying to wait around and see what goes on in the rest of this meeting. But if you don't want to, we won't be insulted if you guys leave, okay? You can stay, though. It's up to you guys.
Cute girls, come on.
Stay here for 3 hours and watch it. Take 3 hours, right?
Be more.
Stand.
I'm gonna put it in the Friday packet.
Okay.
Oh, careful,
Wednesday packet.
Okay.
Yeah, Wednesday.
Congrats, girls.
I'm gonna hand it to him, because you're leaving.
We have someone who wants to say something?
She has something for Mr. Turner. Sit right there.
Okay, let's move on to the mundane business of governing Mountainside. Okay, the next thing we have is Resolution 103, 2015. Keith?
Resolution 103, 2015. This resolution will authorize the borough's Chief of Police, Alan Atanasio, to apply for a New Jersey Department of Transportation 2015 Highway Safety Fund Grant Program under grant number HSF-2015 Mountainside Borough-00012, formerly known as the Safe Corridor Grant. So moved.
We have a motion.
I'll second that.
We have a second. Poll the council, please.
Councilwoman Andre?
Yes.
Councilman Dierkes? Yes. Councilman Messler?
Yes.
Councilman Mortimer?
Yes.
Ms. Turner?
Yes.
Next, we have Resolution 104, 2015. Glenn?
This resolution of the Borough Council of the Borough of Mountainside in the County of Union, New Jersey, coveting to comply with the provisions of the Internal Revenue Code of 1986 as amended applicable to the exclusions from the gross income for federal income tax purposes of the interest on obligations issued by the Borough of Mountainside, authorizing the mayor, borough clerk, chief financial officer, and other borough officials to take such action as they may deem necessary or advisable to the effect such compliance, and designating a $4,834,900 bond anticipation note dated October 30th, 2015, and payable October 28th, 2016, as a qualified tax-exempt obligation pursuant to Section 265B3 of the Internal Revenue Code of 1986 as amended. So moved.
Second.
Poll the council, please.
Councilwoman Andre?
Yes.
Councilman Dierkes?
Yes.
Councilman Messler?
Yes.
Councilman Mortimer?
Yes.
Councilman Turner?
Yes.
Next, we have 105, 2015. Bob?
Having the need for a part-time temporary position in the Department of Public Works, this resolution, at the recommendation of Director Ronald Romack, appoints Matthew Deanna to that position at an hourly rate of $19 per hour, not to exceed 29 hours per week, effective October 22nd, 2015. So moved.
Motion.
Second.
Second, poll the council, please.
Councilwoman Andre?
Yes.
Councilman Dierkes?
Yes.
Councilman Messler?
Yes.
Councilman Mortimer?
Yes.
Councilman Turner?
Yes.
Next, we have Resolution 106, 2015. Renee?
With the retirement of our fire sub-code official, David Mass, this resolution appoints the additional duties to the borough's fire prevention officer, Joseph Popolo, at an hourly rate of $30, not to exceed 20 hours per week. This is a 4-year appointment effective November 1st, 2015.
Second.
Motion. We have a motion and a second. Poll the council, please.
Councilwoman Andre?
Yes.
Councilman Dierkes?
Yes.
Councilman Messler?
Yes.
Councilman Mortimer?
Yes.
Councilman Turner?
Yes.
Okay, next we have 107, 2015, and Bill's not here, so Keith, you'll handle that.
Resolution 107-2015, having received 4 bids for contract 2015-6, television inspection of various sanitary sewers, with the recommendations of the Borough Engineer Mike Disco, following Borough Attorney John Post's review, this bid is hereby awarded to the lowest bidder, being Oswald Enterprises of Belford, New Jersey, in the amount of $53,328. So moved.
Second.
Poll the council, please.
Councilwoman Andre?
Yes.
Councilman Dierkes?
Yes.
Councilman Messler?
Yes.
Councilman Mortimer?
Yes.
Councilman Turner?
Yes.
Okay, next we have Resolution 108, 2015. Deanna?
Having a number of cancellation, Recreation Director Frank Mazzella recommends the following refunds be made. Suzanne Bakalitz, $271. Patty Filiacci, $88. Angela Giftopoulos, $88. Lizette Guzman, $88. Sarah Post-Smith, $88. Vivian Pupo, $78. Alina Ballman, $78. So moved.
We have a motion, we have a second. Poll the council.
Councilwoman Andre?
Yes.
Councilman Dierkes?
Yes.
Councilman Messler?
Yes.
Councilman Mortimer?
Yes.
Councilman Turner?
Yes.
Okay, the next, we're going to take the next two out of order, but I think before we do the ordinance and Resolution 109, 2015, I would like our Borough Attorney, John Post, to just provide the audience, really, and for television, a history of how we wound up where we are right now with these couple of new developments that we have in Mountainside. I think also, John, if you don't object, I'd like to also put this on the Mountainside webpage.
Sure.
Okay?
Sure.
So if you want to take over for a few minutes, John, and explain how we got where we are today.
The ordinance and resolution that are on the agenda for tonight involve the borough's plans for the Barnes Tract. And the borough's plans for the Barnes Tract have their roots in 2 cases that were decided by the New Jersey Supreme Court in 1975 and 1983, setting forth what's come to be known as the Mount Laurel Doctrine. The Mount Laurel Doctrine says that zoning ordinances that do not provide affordable housing opportunities are unconstitutional, and that it requires New Jersey municipalities like Mountainside to zone for and take affirmative actions to provide their fair share of affordable housing. The doctrine defines affordable housing as housing that is affordable for low and moderate income people. Now, as the doctrine developed, developers tried to identify municipalities that did not provide affordable housing, and then they would bring lawsuits to have the courts set aside the zoning ordinances as being unconstitutional. The developers then tried to build projects with 20 or 30 apartments or condos per acre which is far more than the municipality zoning ordinances would have permitted. The lawsuits came to be called Mount Laurel suits or builder's remedy suits. Now, historically, there were 3 Mount Laurel suits brought against the borough. The first one was back in the early 1980s. That suit was successfully defended on the basis that the borough was fully developed and that there was no vacant land in the borough on which to provide affordable housing. The Borough Planning Board adopted a master plan in 1989 that assumed that the borough was fully developed and did not, again, provide for affordable housing. After the first suit, back in 1985, the state legislature, in response to the Mount Laurel issues and decisions that were coming about, created the Council on Affordable Housing, which came to be known as COA, and I'm sure everybody has heard references to COA in recent years. COA's function was to assess New Jersey's need for affordable housing, allocate that need among municipalities on a fair share basis, and then review and approve municipal housing plans that would implement the local fair share obligation. COA's approval of a plan that was proffered or tendered by a municipality meant that the municipality would then be immune from these Mount Laurel or builder's remedy suits. So that was really the legislative function that was envisioned for COA. Now, after the first suit, the second Mount Laurel suit that was brought against the borough was brought by Canada Land Company in October of 2003. Canada Land wanted to build a high-density apartment project on the vacant property out here on Route 22 between the Spanish Tavern and Uncle Bob's Self-Storage. One of their concepts, just to give you an idea about these builder's remedy suits, one of the concepts that Canada Land had for that in that suit for the property involved 2 4-story apartment buildings with a total of 132 units and a density factor of 38 units per acre out there on Route 22. By the time the Canada Land suit was filed, COA had allocated 74 affordable units to the borough, and this governing body had realized that it would have to provide for affordable housing in Mountainside. While the Canada Land suit was pending, the borough spent several years working with a court-appointed special master to develop a Mount Laurel compliance plan based on COA regulations that were in effect at the time. This was back in 2005. The plan involved using the Barnes Tract as a site for a 25-unit affordable housing project for physically disabled persons that would be constructed and operated by a nonprofit corporation that we were engaged in negotiations with at the time. The balance of the borough's allocation of 74 units would be dealt with by means of regional contributions agreements, rental credits, and other means that were available under the COA regulations in effect at the time. Now, again, this is back in 2005. In 2007, Canada Land voluntarily dismissed the lawsuit, this builder's remedy suit that was pending, and the COA regulations that were the basis for the plan that we had formulated to comply with our Mount Laurel obligation were invalidated by the courts. Nonetheless, this governing body, recognizing that there was going to be a long-term obligation here, continued to work on meeting the borough's affordable housing obligations. And that work was underway on October 13th of 2011 when the Pond at Mountainside LLC brought the third Mount Laurel suit against the borough. Now, by October 13th, 2011, when the third Mount Laurel suit was brought against the borough, a number of things had happened that were very important. Number one, the courts had invalidated, as I mentioned before, the COA regulations, not just once, but several times. Governor Christie had been elected by that point, and he had attempted to abolish COA entirely. And municipalities in this state, like Mountainside, were really left without any guidance as to how their affordable housing obligations would be calculated and without guidance as to how they would go about meeting their affordable housing obligations. Now, notwithstanding the chaos and confusion that prevailed when the Pond case was filed, and I think chaos and confusion is really the appropriate phrase to describe the state of the law as it related to affordable housing at that time, this governing body again recognized that when the dust settled, it would confront even more Mount Laurel suits, like the Canada Land suit, if it did not make a plan. And so accordingly, the borough asked the assignment judge in Union County, Karen Cassidy, to appoint retired Judge Eugene Serpentelli as a special master to help the borough design a new Mount Laurel compliant plan. Remember, the plan we had designed had been invalidated because the regulations it was based on had all been thrown out by the courts. Before Judge Serpentelli, who was the special master we requested, but before he retired, he had authored many of the most important decisions implementing the Mount Laurel Doctrine, and he's recognized as a leading authority regarding Mount Laurel jurisprudence in this state and indeed in the country. The goal was that once Judge Serpentelli had approved the plan that we had worked out with him, it would be submitted to Judge Cassidy for approval, and a judgment of compliance and repose, which would give the borough the same kind of protection that COA had been providing before it ceased functioning, would be available to the borough. Judge Serpentelli worked with the borough and the parties in the Pond case to formulate a Mount Laurel compliance plan for the borough. By December 2013, the plan had been fully prepared. Judge Serpentelli had approved it, and it was ready for a fairness hearing before Judge Cassidy, again, the assignment judge in Union County. Now, the borough plan that we worked up with Judge Serpentelli determined that the borough's affordable housing allocation for the period 1987 to 2018 was 123 units. 6 of those units were satisfied by an existing ARC home in the borough, so there were 117 units to be actually dealt with. The plan anticipates that 16 affordable housing units will be constructed on 3 sites that are identified in the plan, and the remaining units are provided for in an overlay zone to be constructed if, as, and when the property owners in the area covered by the overlay zone determine that they want to do so. The density factor incorporated in the plan is 6 units per acre, with 20% of such units being set aside for affordable units. Recall when I talked about builders' remedy lawsuits that the kinds of density factors that were being suggested in these builders' remedy lawsuits were 20 to 30 units per acre, and indeed one of the Canada Land concepts suggested 38 units per acre. So our plan provides for 6 units per acre, with 20% of those units being set aside for affordable units. The 16 affordable units that are going to be constructed are on sites identified in the plan, and they're distributed among 3 properties. One property is Block 3A, lots 17 and 18, which is approximately 5 acres in size and will accommodate 23 market units and 6 affordable units that are all age restricted. This is the property that was owned by the plaintiff, or that is owned by the plaintiff in the Pond case. The second site is Block 14, Lot 14, which is approximately 5.4 acres in size, and that will accommodate 24 market units and 6 affordable units and approximately 6 retail stores. That's the Barnes Tract, which will be, I started out talking about earlier, and we'll be coming back to. The Barnes Tract, as we all know, is owned by the borough. And then the third site is Block 15I, lots 48B, which is approximately 8.3 acres in size, and that's the property next to Brighton Gardens. Only about 3.2 acres of that property is usable or developable, and so that will accommodate 23 acres, of which 4 will be affordable units. Now, the fairness hearing that was scheduled before Judge Cassidy was advertised and scheduled and held on February 26, 2014. Nobody appeared at that hearing to object to the plan. At the conclusion of the hearing, Judge Cassidy entered an order approving the plan and remanding the case back to the planning board and to this governing body so that the plan could be implemented. Now, as the borough went about implementing the Mount Laurel plan that Judge Cassidy had approved, the first thing that was done was that the planning board held a public hearing, which was advertised and then passed a resolution on May 27, 2014, finding that the plan was consistent with our master plan. After the planning board took that action, the governing body adopted the requisite amendments to our zoning ordinance, which again were advertised and considered at a public hearing on June 17, 2014. Nobody appeared to object to before the planning board or indeed before this governing body when it adopted the ordinance. Now, that constituted compliance with Judge Cassidy's February 26, 2014 order, and so at that point, the borough was entitled to a judgment of compliance and repose from Judge Cassidy That was entered on September 10th, 2014. Now, it's important to understand that as long as the borough complies with the terms of that judgment that was entered by Karen Cassidy, Judge Karen Cassidy, on September 10th, 2014, we do not need to worry about any more builder remedy suits. We are immune. That is the legal effect of the judgment of compliance and repose. Now, as I mentioned before, one of the components or one of the pieces in the plan that Judge Cassidy approved and in the plan which gives us got us immunity involves the utilization of the Barnes Tract. Specifically, the judgment incorporated Judge Serpentelli's report where he approved our plan, and what he said regarding the Barnes Tract was, in his report, was as follows, and I'm quoting now from Judge Serpentelli's report. Obviously, the borough is committed to utilize its property designated in the plan as Site 2, known as the Barnes Tract, for affordable housing purposes. And I want to emphasize that the special master recognized that the borough was committed, Judge Cassidy recognized that the borough was committed, and so that we are committed as long as we adhere to the notion that we want the benefit of the judgment of repose, we are committed to using the Barnes Tract for affordable housing purposes. And that's necessary in order to preserve the immunity that I mentioned before. So our town is committed to using the Barnes Tract as we went about implementing what we had agreed to do in our plan. The question was, how are we going to do it? And there were a couple of basic options available to the borough. One was to simply sell the Barnes Tract at public auction pursuant to NJSA 40A-1213, and the second option was to declare the Barnes Tract in need of redevelopment and then sell it to a developer under the New Jersey Local Redevelopment and Housing Law, that's NJSA 40A-12A1 et sec. We chose the second option, the redevelopment route. And we chose that option because it gives us, the borough, far more control over the actual development process, including what the development will eventually look like, than the first option. If we had simply sold the Barnes Tract at a public auction, well, there would have been certain limited restrictions and conditions on the use of the property, but they could not have been any more stringent or any more demanding a standard than what is in our zoning ordinance regarding the Barnes Tract. With the redevelopment option, we can go a great deal farther than that by way of exercising control over the redevelopment process. Now, the selection of the redevelopment option does not, however, alter in any way the fact that in addition to the retail units, there will be 30 housing units on the Barnes Tract, of which 6 will be affordable. That is one of the centerpieces of our affordable housing plan, which, as I said before, resulted in the borough obtaining the judgment of compliance and repose. So on November 5th, as we went about then implementing the redevelopment option, the Planning Board considered a report from John Chadwick, who's our planning expert, and the Planning Board passed a resolution that the Barnes Tract should be a redevelopment area. After receiving the resolution from the Planning Board, this governing body considered a redevelopment plan for the Barnes Tract that Mr. Chadwick had also prepared. And having considered that redevelopment plan, the governing body has determined to take 2 steps tonight that are required by law to continue to implement the redevelopment option. First, we're introducing on first reading an ordinance which is adopting the redevelopment plan for the Barnes Tract that was prepared by Mr. Chadwick. That ordinance and the plan will be advertised, and then we'll have a second public hearing on the ordinance and the plan and vote for that at our December 29th meeting. The second thing we're doing tonight is passing a resolution. Thank you, Keith, for explaining to everybody what a resolution means. But we're sending the redevelopment plan back to the Planning Board and asking the Planning Board to make sure that everything that's in that plan is consistent with the borough's master plan. And we're precluded by law from moving forward with the redevelopment plan until the Planning Board has so advised us. And with respect to that question, we expect the Planning Board to address that question and pass a resolution at their December 24th meeting. So assuming that all goes as planned, in early 2016, we'll be in a position, the borough will be in a position to circulate an invitation for proposals to anyone who has expressed an interest, who has been identified as a potential partner of the boroughs in the redevelopment of the Barnes Tract.
Thank you, John.
You're welcome.
And we're going to put that on the website?
Yes, I'll give Martha a copy.
Okay, and also, I think at the December 29th meeting, we'll also recite that history again, because just so the audience is clear, tonight we're passing an ordinance on first reading where there is no public participation by law. The second reading, which will occur on December the 29th, is the opportunity for the public input, and after the public input, then the borough will consider adopting that ordinance. I want to repeat again, it's December 29th for anyone that's interested in making comments on the fact that we want to designate the Barnes Tract as an area in need of redevelopment.
Mr. Mayor, I just wanted to add one more thing. The affordable housing units, the 6 units on the Barnes Tract, Mr. Post had mentioned they are low to moderate income. And just so everybody knows, Mountainside is considered in Region 2, which is part of Essex, Morris, Union, and Warren counties. The only information I was able to get, and I know the income limits are much higher than what, well, not much, but higher than what I'm about to say this evening. I was only able to get the 2011 regional income limits for Region 2. And for a single...
I think John has some updated.
Oh, do you have them?
I do have the updated...
No, if you don't, it's back in 2011, for a single, the low income was $31,295, up to the moderate income of $50,072, and that was for a single. Two-person, the moderate income was $57,225. I remember last time I checked, and I was able to get to 2015, I think it was closer to $60,000 a year of total income, and that excludes assets such as a primary residence and other various assets. It's strictly based on the couple's income. So if somebody were to be interested in one of those affordable units, a senior citizen couple from the borough of Mountainside, their income could be upwards of $60,000, maybe a little bit more than $60,000, excluding their primary residence value and certain other
I think that's
assets.
changed, though. John Chadwick said they now consider the other assets in addition to income.
Do they?
Yes.
When did that happen?
I don't know, but at the planning board meeting the other night, he made it very clear that if you sold your primary residence and had a large amount of
Yes,
money in the bank,
if the primary residence is sold,
Sold.
yes, it does come into consideration. But the income, I heard some, rumors out there that the income was practically nothing, and, although $60,000 isn't a ton of money, that is the income limit for two in an affordable housing unit. I just wanted to clear some of that up. And maybe Mr. Post can give us exact figures if you have the updates.
What I have, Keith, the mix between moderate and low income is going to be 50-50 moderate, or 50% moderate and 50% low income in our affordable housing
So it'd be 3
units.
and 3 at the Barnes Tract.
Exactly. And I'm looking at the 2014 schedule. It's the same schedule I think that you had. And the range for Region 2, as you correctly indicated, Mountainside is in, runs from, at the moderate level, if it's a one-person household, at the moderate level, it runs from a low of, from $50,744 if it's one person, to a high, if it's an 8-person household, of $95,689.
So it's up,
And
20% from my figures.
Right, and the low category is, for a one-person household, $31,715, and for an 8-person household, $59,806.
And what's a 2, John?
A two-person
Two-person moderate,
moderate is $57,993, and a low is $36,246.
okay. And that was as of 2014, and I'm sure there's been a slight bump up since then.
Okay, very good. So should we do the ordinance next, John?
Yes.
The correct procedure. Okay, so next we want to have a motion to introduce ordinance number 1240-2015. And Glenn, you want to do that, please?
Ordinance adopts the redevelopment plan of the Barnes Tract, Block 14, Lot 14, as outlined by our Borough Attorney, John Post.
Second.
We have a motion, we have a second. There's no public input on this. Poll the council, please.
Councilwoman Andre?
Yes.
Councilman Dierkes?
Yes.
Councilman Messler?
Yes.
Councilman Mortimer?
Yes.
Councilman Turner?
Yes.
Now, again, the public hearing where there will be public input is on December 29th. Next, we have to go back now to Resolution 109, 2015. Keith, you want to handle that?
Resolution 109-2015. This resolution will attest that the Mountainside Mayor and Council have determined that the Barnes Tract is in fact an area in need of redevelopment under NJSA 40A:1A-5, small a et al. Furthermore, referring a proposed redevelopment plan to the Mountainside Planning Board for review pursuant to NJSA 40A:12A-7E. So moved.
We have a motion, do we have a second?
Second.
Poll the council, please.
Councilwoman Andre?
Yes.
Councilman Dierkes?
Yes.
Councilman Messler?
Yes.
Councilman Mortimer?
Yes.
Councilman Turner?
Yes.
Okay, so I think next we have to pay some bills. Glenn?
Yes, we do. Be it resolved by the Mayor and Council of the Borough of Mountainside that the following bills of the persons named for the amounts stated below have been duly audited and found to be correct this 24th day of November 2015. The same be paid after council's review if and when funds are available, and that the mayor, council president, administrator, and treasurer are hereby authorized and directed to sign and deliver warrants for same. Total $279,195.36.
Second.
We have a motion, we have a second. Poll the council.
Councilwoman Andre?
Yes.
Councilman Dierkes?
Yes.
Councilman Messler?
Yes.
Councilman Mortimer?
Yes.
Councilman Turner?
Yes.
Do you have any council comments?
I'd like to wish everybody a very happy Thanksgiving.
And during these, I hate to call them crazy times that we live in, and during the holiday season, be extra careful. Most importantly, if you see something, say something, okay? It could save a life, maybe even your own, if you're taking public transportation. If you see something left around, a bag, I would rather see you approach one of the police officers or security people and point it out. I'd rather see that you made a mistake than didn't say anything at all. So please, this season and during the holiday season, considering the events that are going on around the world, if you see something, say something. I want everybody to be safe.
Especially in our own community. If you see something suspicious, you see someone suspicious walking around, something out of place, a car out of place, anything like that, please call the police. They'll have no problem going out and investigating it. They just don't even hesitate, because that hesitation may be what's going to make the difference between stopping something disastrous and something disastrous happening. Also, I'd like, just for the record, I know that Mike Disco worked on a report for Mrs. Embler. Is it Embler?
Bellac.
Mrs.
Bellac.
Mrs. Bellac.
1238 Poplar.
She's been at the meeting the last couple of months. Mike did complete a report. He's going to pass that report on to her and also to the council, and we'll be considering some of the options that that he has laid out in that report in connection with that situation by her property. In addition, we have the Mountainside tree lighting, which is going to take place on Saturday, December 5th at 4:30. That's not this Saturday, it's a week from Saturday. I'm told all the lights and and hopefully even our star is going to work properly for the event, but you can never tell with these things. Also, the fire department's Santa Express, if you want to register for that, you must register in person at the firehouse on either Sunday, November 22nd from 2 to 6, or Monday, November 30th from 6 to 8.
Oh, I think that's the 29th, Mr. Mayor?
What did I say, 29th?
29th and the 30th? Sunday and Monday?
I'm sorry, Sunday, November 29th at 2 to 6, and Monday, November 30th at 6 to 8. I'm sorry if I said something differently. Also, we have the Mountainside PAL Breakfast with Santa at the Elks Club on December 12th. There's 2 seatings, one at 9 a.m. and one at 10:30. If you want to register, the deadline is December 1st. You can go online to the Mountainside PAL website to download the information. I actually think you can register on the website also.
Can I add to that, please?
Sure.
December 12th, the Hatfields House is going to have the Adult Gingerbread Open House with wine and cheese, which will be hosted by Stu Leonards. And then the following day, Sunday, December 13th, Family Fun Gingerbread Open House for family and children. Lots of crafts that day, too. So please come and join. Thank you.
And I just wanted to say thank you, Zoe. You know who you are.
Okay, so we need a motion to adjourn.
So moved.
Okay, so adjourn, guys.